For the first time in legal history, a jury has ruled that Meta and Google are negligent for the harm their platforms cause to real people. Two of the most powerful corporations on Earth, with armies of lawyers and billions in resources, have been held legally responsible. This verdict does not just affect these tech giants. It could reshape the entire internet as we know it. And if you use social media, this case directly affects you. Welcome to Court Decoded. Today we cover the landmark trial that held big tech accountable for social media harms, examining how the jury reached this historic verdict and what it means for the future of online platforms everywhere. This case did not emerge from corporate boardrooms or regulatory agencies. It emerged from devastated families. The plaintiffs in this trial were parents who lost children to suicide, families whose teenagers developed severe mental health conditions, and individuals who claimed social media algorithms deliberately exploited their vulnerabilities for profit. These were not abstract policy arguments. They were deeply personal stories of young people whose lives were derailed by platforms designed to maximize engagement at any cost. The families alleged that Meta and Google knew their products were causing psychological harm, particularly to adolescents, yet continued operating without adequate safeguards. Internal documents suggested both companies possessed research indicating the dangers their platforms posed. Armed with this evidence and united in their grief, these families sought something unprecedented. They wanted a jury to declare that big tech had a legal duty of care and that Meta and Google had breached it. For decades, Section 230 of the Communications Decency Act served as an impenetrable shield for tech companies. This federal law states that online platforms cannot be treated as publishers of user-generated content, effectively immunizing them from most lawsuits related to what users post. Every previous attempt to hold social media companies liable for harm had crashed against this legal fortress. But this case took a different approach. The plaintiffs argued they were not suing Meta and Google for content posted by users. Instead, they claimed the companies were negligent in how they designed their products. The algorithms that recommended harmful content, the features engineered to maximize addictive usage, the deliberate targeting of vulnerable young users. This was not about what users said. This was about what the platforms themselves built. For the first time, a court allowed this product liability theory to proceed to trial, creating a potential pathway around Section 230 protections. The trial revealed damning internal communications. Plaintiff attorneys presented documents showing Meta executives discussing research that Instagram made body image issues worse for teenage girls. They showed Google employees raising concerns about YouTube rabbit holes leading users toward increasingly extreme content. Expert witnesses testified about the psychological techniques embedded in these platforms. Variable reward schedules, similar to slot machines, kept users scrolling. Autoplay features prevented natural stopping points. Notification systems triggered anxiety when users stepped away. The plaintiffs painted a picture of companies that understood exactly what they were doing. These were not accidental harms. They were predictable consequences of deliberate design choices made to increase profits. Former employees testified about being overruled when raising safety concerns. The message was consistent. Engagement metrics trumped user well-being, and vulnerable teenagers paid the price. Meta and Google deployed their considerable resources in defense. Their attorneys argued that social media platforms are tools, and tools cannot be held responsible for how people use them. They compared their services to automobiles or telephones, technologies that can cause harm but are not inherently defective. The defense emphasized parental responsibility and individual choice. Users agreed to terms of service. Parents could monitor their children's usage. Alternative apps existed for those who preferred different experiences. No one forced anyone to use Instagram or YouTube. Defense experts challenged the causation claims. Mental health issues have multiple complex causes, they argued. Isolating social media as the specific reason for any individual's harm was scientifically impossible. The defense also highlighted the benefits of social media: connection, community, education, and creative expression. Millions of users experienced positive outcomes. The platform should not be punished because some users had negative experiences. Both sides marshaled armies of expert witnesses, transforming the courtroom into a battlefield of competing scientific claims. Psychologists testified about adolescent brain development and heightened susceptibility to social comparison. Neuroscientists explained how dopamine reward systems could be hijacked by algorithmic content delivery. Former tech employees provided insider perspectives on growth at all costs corporate cultures. Defense experts countered with studies showing no conclusive causal link between social media use and mental health deterioration. They highlighted methodological flaws in plaintiff research and presented alternative explanations for rising youth mental health concerns. The jury faced a daunting task, evaluating complex scientific testimony, weighing competing studies, and determining whether these platforms met the legal standard for negligence. Neither side offered simple answers. But the plaintiffs had one significant advantage. They could point to the defendant's own internal research suggesting awareness of harm, research the companies had not acted upon. After weeks of testimony, the case went to the jury. 12 ordinary citizens now held the fate of the most powerful technology companies in human history in their hands. They reviewed thousands of pages of evidence. They considered the grieving families. They weighed the corporate defenses. Deliberations stretched across multiple days. Legal observers noted the unprecedented nature of the decision facing these jurors. A verdict against Meta and Google would not merely award damages to these specific plaintiffs. It would establish that social media companies owe a duty of care to their users, a duty they can breach through negligent product design. This was bigger than one case. This was potentially the foundation for an entirely new framework of platform accountability. The courtroom fell silent as the jury returned. Attorneys straightened their notes. Families clutched each other's hands. The future of the internet hung in the balance. The jury found Meta and Google negligent. In a decision that sent shockwaves through the technology industry, 12 citizens determined that these tech giants had breached their duty of care to users. The specific findings varied across plaintiffs, but the core message was unmistakable. Social media companies can be held legally responsible for the harms caused by their platform designs. Families embraced in the courtroom. Attorneys who had spent years building this case finally exhaled. Outside, legal experts immediately began analyzing the implications. This verdict represented the first successful negligence claim against major social media platforms. It demonstrated that Section 230, while still powerful, was not absolute. When companies make deliberate design choices that foreseeably harm users, they may face consequences. The damages awarded were significant, to quote, but the legal precedent was far more valuable. A roadmap now existed for future plaintiffs across the country. Legal experts immediately recognized the transformative potential of this verdict. Hundreds of similar lawsuits pending across the country now had a blueprint for success. State attorneys general investigating social media harms gained powerful ammunition. Congressional efforts to reform Section 230 received fresh momentum. For the tech industry, the calculus fundamentally shifted. Designing addictive features targeting vulnerable users now carried genuine legal risk. Internal research documenting potential harms became potential courtroom exhibits. The move fast and break things philosophy suddenly looked like potential negligence. Some analysts predicted a chilling effect on innovation. Others welcomed long overdue accountability. Platforms might implement meaningful age verification. Algorithmic recommendations could be redesigned with safety in mind. The attention economy might finally face constraints. Meta and Google announced plans to appeal, ensuring this legal battle would continue for years. But regardless of appellate outcomes, this verdict had already changed the conversation about big tech responsibility forever. The jury's finding of negligence against Meta and Google marks a turning point in technology law. For the first time, a court has held that social media companies owe a legal duty of care to their users, particularly young and vulnerable individuals, and that deliberately designing addictive, harmful features breaches that duty. While appeals will certainly follow, this verdict establishes that Section 230 does not provide unlimited immunity when companies make conscious design choices that foreseeably cause harm. The legal lesson is profound. Corporations operating in the digital space must now consider that internal knowledge of product dangers, combined with failure to act, can result in negligence liability. The age of absolute platform immunity may be ending. If you found this landmark case fascinating, hit subscribe and tap the notification bell to stay informed when the appeals unfold. Share this video with anyone who uses social media. The law is evolving, and these cases affect everyone online.